Good afternoon, ladies and gentlemen. I want to welcome everybody to the monthly meeting of the City of Des Moines Zoning Board of Adjustment. This board has the power under Iowa law and the zoning ordinance of the City of Des Moines to hear requests for variances and exceptions from the regulations in the zoning ordinance, conditional use permits, and appeals from the decision of the staff in the administration of the zoning ordinance, and to make decisions in such matters. The members of this board are citizens of the City of Des Moines and have been appointed to the board by the City Council. The board members are volunteers and receive no compensation for their public service. I'm going to go ahead and introduce our board and staff members here. On the audience's left is Brooke Rosenberg. Next to him is Cindy Smith. Absent today is member Cherie Mortiz. I'm Mel Pins, board chair. Next to me on the audience's right is Larry McDowell, our legal counsel. Next to him is Linda Westergaard. Next to Linda is Dave Gare. And Jake Christensen is our final member of the board. Jake is absent today. Our staff also with us today are Bert Drost, city planner. Is Eric with us today? He'll be in later. Eric Lundy, city planner. Anupreet Minhas, city planner. And Sue Ann Donovan, zoning enforcement officer. I'm going to give everybody a little background on the procedure here. For some of you, this may be the only time you'll be in front of this board. For some of you who have been here before, just a few reminders on how we conduct the hearing. First up, this is an open and informal meeting. It is being recorded. It should be broadcast live on the City of Des Moines cable channel. The board members have received a copy of the agenda for today's meeting as well as the staff recommendation. There are copies of the agenda and the staff recommendations available for the audience in the trays by the door. So if you want to kind of know the agenda flow and at least what the recommendation is from the staff on the items, feel free to hop up and grab one of those. The board is required to base its decision in these cases upon the criteria established by law for the type of relief sought by the applicant. The law applicable to each case is identified in the written staff report, and if the facts, as determined by the board, demonstrate that the criteria established by law for granting the relief has been satisfied, then the board must grant the relief. Otherwise, the board must deny the relief. Each appeal today will be announced in order, and the staff will present a brief explanation of the appeal. Any written comments received by the staff prior to the hearing will be distributed to the board or otherwise identified during the staff presentation. The appellant or the representative of the appellant will then be allowed to speak first and will be allowed up to 10 minutes to present their appeal. Anyone else present in support of the appeal requested will then be allowed up to 5 minutes each to present his or her comments. Anyone present in opposition to the appeal will then be allowed also up to 5 minutes each to present their comments. The applicant will then be allowed up to 3 minutes for a rebuttal or other closing comments. All speakers are requested to speak from the podium here to your left and begin their presentation by giving both their name and address. All speakers are requested to focus their comments only upon those facts that demonstrate whether or not the criteria established by law has been satisfied. The board will then close further public comment on the agenda item, and the board will then immediately deliberate the request and make a decision right here at the hearing today. If your appeal is approved today, we ask that you wait until tomorrow to go to the Permit and Development Center for any building permits. Items listed on the consent portion of the agenda, which is the first portion of our agenda here, we will not plan to individually discuss those items. We will consider them for approval as a group in accordance with the recommendation in the staff report, unless an individual present or a member of this board requests that the item be removed from the consent agenda and separately considered under the public hearing agenda. The decisions of this board can only be appealed in the Polk County District Court. So if you believe you've been harmed by an error made by this board, your only remedy is to seek relief through the district court within 30 days of the filing of the board's decision and order. If you believe the zoning regulations applied by this board are wrong, you may petition the City Council to change those regulations. All material written or otherwise used today as part of any presentation will become a permanent part of the record and will not be returned. So if you want to share some photographs or some documents, you either have to leave those with us, or we can make probably a copy of those would suffice. Just some quick housekeeping items. We ask that here in the audience, please avoid any conversation so as not to be disruptive or distracting from the hearing that is in progress. Ensure that your cell phone ringer has been silenced. And once the agenda item you are interested in has been completed, you're welcome to leave the hearing. Feel free to stick around if you'd like to armchair quarterback some of this, but again, as soon as your item has been heard, you're welcome to leave. If you need to use a restroom, you can leave through the main door here and walk through the atrium to the far north end, and restrooms are on your left. Subject to the length of the agenda, if we get past the 3 o'clock to 3:30 mark, we may take a 10-minute break if needed. Otherwise, we kind of plan to plug through this and get everybody's items out here to be heard. So, first item of business then would be to look at our consent agenda. At this time, we have items 1 through 8 on the consent agenda. Any changes, Bert?
We don't have any changes to the 8 that are on there. However, item number 14, which is an appeal at 1221 Birch Lane, we feel that that could be moved to the consent agenda if the board is comfortable with it. It's an item where they're proposing to construct a garage that would be within 24 feet of the front yard or the front property line. So they need an exception of 8 feet less than the calculated average 32-foot front yard setback. So if the board is comfortable moving number 14 to the consent agenda, staff would be in support.
Any discussion or motions by the board? On item 14, to consider that on consent, any thoughts? You good? Oh, sorry, Brooke. Yeah, is there anybody to speak in opposition to item 14? Okay, hearing none. Anybody want to put that on consent?
Hearing no objections, I would put item 14 on the consent agenda. I would move.
Okay, we got a move by Cindy, second by Brooke. All those in favor, raise your right hand, say aye. Aye. Opposed? Okay, no opposition, motion carries unanimously. Okay, so we have items 1 through 8 and item 14. Those include exceptions, variances, and a special permit. Any motion to approve the consent agenda?
Can we read through them one time?
Sure. For the audience's benefit, just depending on why you're here, item 1 is a variance request at 2752 Chicago Avenue. Item 2 is an exception request at 4 Lincoln Place Drive. Item 3 is a variance at 2816 Beaver Avenue. Item 4 is an exception at 2726 47th Street. Item 5 is an exception at 1215, would that be your street?
Yeah.
Item 6 is a special permit for 979 Oak Ridge Drive. Item 7, an exception and variance request at 111 and 130 East 3rd Street. Item 8 is an exception at 604 44th Street. And then item 14, an exception at 1221 Birch Lane. Before we vote on these, is there anybody that wishes to speak against any of these items I just listed? Okay. So hearing none, do I have a motion to approve the consent agenda as presented?
I would move staff recommendations for the consent agenda as stated, including item 14 for the variances, exceptions, and special permits.
And I'll second that.
Okay, we got a motion and second. All those in favor say aye. Raise your right hand. Opposed? None. Okay, motion carries unanimously. So if you're here for item 1 through 8 or item 14, you've been approved, and you don't have to stick around. So good to see you, Denny. Okay, so this is for a regular agenda, then we would start with item number 9, and I'd like to have Bert and or Larry give us a little bit of background on this item.
Before we move into these items, item number 12 has asked for the continuance.
My apologies, Bert,
June
yes.
25 meeting.
Okay, before we start the regular portion, we do have a request for a continuance for a conditional use permit at 1401 Buchanan Street. Thank you, Bert.
And they've requested the continuance because they're still in the process of having an audit done, and the audit will determine whether or not they're a limited food and retail sales establishment, or if they need to be renoticed as a liquor store. So
Is this the first time this would be appearing on the agenda here?
this is,
Okay.
would be the first continuance on this one.
Okay. All right. Any questions or thoughts from the board?
Which item was it?
12,
Item 12.
1401 Buchanan.
Do we have anybody here in the audience that wishes to speak against item 12? Because if you come down today, we'd be happy to hear your comments for a few minutes if you have any concerns. Otherwise, we may look at continuing this to next month when we have some more information. Okay, don't think we have anybody there. A motion for continuance then?
Mr. Chair, I'll move to continue item 12 to the June meeting.
And do I have a second? All right, thank you, Dave. Motion and a second. All those in favor to continue item 12 to the June regularly scheduled Board of Adjustment hearing, raise your right hand, say aye.
Aye.
All right, motion passes unanimously. Okay. All right, so now, for getting back to the items left on the regular portion of the agenda, we would be starting with item 9. And I'd like to have Sue Ann give us a little background on that, why we are here today.
Chair, members of the board, we are here at the behest of council, who has remanded this back to the board for reconsideration. In order to go through the reconsideration, I thought I would just do a presentation to the board, similar to what was previously
Okay.
presented.
Appreciate that.
So here, to start with, is the remand from council, asking that the board reconsider this. As a result of that action, we renoticed the people within 250 feet. So here is our current consent map. I'll send around the cards that were received. As a reminder to the board, here are photos of the particular structure in question at 1617 Oakland. The brief history on this is that Harbor of Hope previously owned the structure, and it was granted a variance from separation of other supervised group residents in order to run a supervised group home in this structure. The Board of Adjustment attached a condition onto that approval for the variance, stating that the variance elapsed when the Harbor of Hope moved out. Harbor of Hope relocated. The structure stood empty for a number of months, and then Kelly Wolfcool bought it. When she occupied it, it came to the attention of staff. There was a neighborhood inspection division inspector in the area who talked to her and told her she shouldn't occupy it until she had proper authority, either through zoning or the rental certificate process. Should be noted that this property was downzoned. It's now an R160 lot. There are certain things that are allowed on the R160, single-family dwelling, supervised group home as long as it's not within a quarter mile of another home, supervised group home, and it does not meet those requirements. Ms. Wolfcool actually occupied the structure as a correctional placement facility. March 29th, we sent her notice saying that she needed to bring it into compliance with zoning requirements. She came in for a pre-application, and that is exhibit number 1, is that letter of March 29th. Exhibit number 2 is the pre-application site plan conference minutes. That's exhibit number 2. Kelly did come in, Ms. Wolfcool came in, met with staff about how to legalize or legitimize the use of that structure as a proposed transitional housing recovery center. It's always been a little difficult in dealing with this case, trying to determine exactly what she wants to do with it. It did come down that it was going to be occupied as a correctional placement facility. And through that process, she went into a rezoning process. At one point, she wanted to do it half correctional placement, half supervised, sort of a combination use, and we told her that that was not going to be possible. So she was sent another letter on August 26th stating that she couldn't do that particular use. In the meantime in there, the structure lost water service and had a water main break and was vacated. We informed her on April 26th of 2013, and this is exhibit number 3, that she couldn't reoccupy the building. Now, she had told people at pre-application that she wouldn't reoccupy it until the zoning was brought into compliance. She went ahead and reoccupied it. We also have, in order to bring this into compliance, we had rental code issues. So we did a rental code inspection to make sure that the people who were in there that we were having trouble getting out of there were safe. We got an order against her to vacate it. She didn't do it, so we went in and got an order granting the plaintiff's motion to vacate the structure and for a writ of removal. That's defendant's exhibit number 5. It's still occupied. Part of that order was that she was going to prove to staff that it wasn't being operated as a supervised group home. I'm still not convinced she's not operating it as a supervised group home. In fact, at the last hearing, she had told the board through her attorney that she had taken down the website for one-way recovery. Mr. Hildebrand had brought in a copy of the website that was up on that date. This is the copy of that. I confirmed it was still up during that date, so she was still advertising at that point that she was one-way recovery. Exhibit number 6, these are, for sort of the accumulation of facts. She has a Facebook one-way recovery. It is still up and running, where it says One-Way Recovery is a nonprofit organization created to help men who are recovering from substance abuse. We provide a safe and structured environment for men to live and seek skills to successfully recover. So that's still up and running. On her webpage, on her Facebook page, she says that she is nonprofit organization management. One-way recovery again, that's exhibit number 7. She on her LinkedIn pages, she says she's one-way recovery director. Exhibit number 9, again, executive director of one-way recovery. This is her, this was her LinkedIn, this is her Facebook page. She has up on the Des Moines meeting schedule for AA, that she does AA meetings in this on Wednesday nights. That's exhibit number 10. On May 16th, I printed off the One-Way Recovery Facebook page, and it said at that meeting they're going to discuss having man-to-man talk with your daughter date. That was part of the meeting that first scheduled for that particular AA meeting, I believe. It's a little hard to figure that out, but this stuff is all over the web that she's still doing meetings there. Exhibit number 11, she has she has tax exempt status for this property. So she is holding out still to the county that she's getting tax exemption. She doesn't pay taxes on this property as a charitable exemption under property taxes. It troubles me as a zoning enforcement officer that she says she's going to be a boarding house, but she doesn't act like a boarding house when she holds herself out to the public online. Council remanded this with what I took from sitting in the audience listening to it, upset that this wasn't going back to the R160 district regulations and being occupied as a single family, or at least under the R160 district regulation requirements. Staff thought a boarding house would be good. We've stayed with that staff rec. That's what's before you. I, as the enforcement officer, am not convinced that this will be a boarding house if she gets the boarding house use. So that's where we're at. You are charged with reconsidering this.
Questions for Sue Ann?
The council sent it back to us to reconsider. What was there's nothing in my notes saying why they did it. Was there any specifics?
My best recollection is Councilmember Moore was upset that he believed that she had provided falsified documents during the rezoning. What I believe that she did was she had signatures on a petition that she submitted to the Plan and Zoning Commission, and she had taken that list, handwritten it for another hearing instead of having the original signatures submitted as the document that was the petition.
And that was a list for what?
Or people saying that they supported rezoning.
May I step in? I wasn't at the meeting, but I did see it on the video, and I don't recollect that being part of the conversation at council at the table. So that's not part of the official record then. I just want to make that clear.
Okay, and then the exhibits you showed us, the Facebook and LinkedIn, does it connect specifically between what her profession is and this facility, this address?
She's held this address out as one-way recovery. She holds it out in the meeting places for AA, that one-way recovery is at this address. These are sort of links that she holds herself out as being the director of one-way recovery. She goes on the AA website and says, we're having meetings at one-way recovery at 1617 Oakland. So,
Suanne, my question is, and I don't see it in the paperwork today.
Turn your mic on, Linda.
Yeah, the last meeting, when you looked at the police records that you provided to us, there were quite a few police calls to that address. And I just hope that we can maybe see those again. I don't see it in the packet today, but if our fellow board members will recall, there were an impressive amount of police calls to that address, if I'm thinking
I'll
of
see
it
if I
correctly.
can find it.
And Linda, you're not just stating the within the 500 feet radius, but specifically at that address?
Specific at that address, I believe. As I recall, that's...
And I'm not finding that
Okay.
piece of paper right now.
We can maybe come back to that.
Yeah.
I'll keep looking for it.
I saved it, but I just didn't bring it.
Sue Ann, when I think of a boarding house, this is a statement and then a question here for you. When I think of a boarding house, I think of a place where people are just living temporarily. Maybe they're a student teacher for a semester. Maybe they're a nursing student at Mercy. It's where people, for non-related reasons, would lodge temporarily. You know, they rent a room, basically. That's my understanding of what a boarding house would be. Is that the general definition or thought process as
That's
well?
what we would consider a boarding house, is that you have a room, you rent, you may have shared kitchen facilities.
Okay.
But you have a private room of your own.
Right.
That you can rent and
Right.
come and go as you please. No hours, that's
Sure.
your space.
Sure. With, and even with the concern by the council, my inclination at our last hearing was, well, if this operates as a boarding house, it's a very large structure, I wouldn't maybe see that kind of concern with it. But what I do see with what you've presented here, and this is my question, when we talk about one-way recovery being like a term, a nonprofit leading to, group living where people have needs and concerns and are recovering from various ailments, that's not what I thought this was about. And with what you just provided, I don't think you had or we saw some of those exhibits last month, did we?
The unfortunate thing last month is that I didn't realize that the website was still up until the
Exactly.
meeting was closed.
Okay.
And you
Right.
guys were in consideration,
Sure,
and
sure.
there's always that protocol.
So with council asking us to look at this again, you have some new information which we did not have to consider during our deliberation last month. Is that correct?
Correct. I was under the impression that she had taken down those websites and that it was no longer being advertised as this place was being used for this.
Right.
I'm now concerned when I go back through
Sure.
websites that she hasn't stopped the use,
Yeah.
that it is still.
And when you look at a boarding house or a bed and breakfast or even a multifamily unit in general, do they usually operate as a nonprofit?
No, those wouldn't be nonprofits.
Okay,
You get nonprofit status if you are providing services, but you're not making money for it.
Right.
At a boarding house, it's a landlord-tenant relationship,
Yep.
and you would be making money.
right, okay. Any other questions for Sue Ann? Okay, all right, we may come back to you, okay. Anything else from staff? All right, so with those opening comments from staff, the appellant or the appellant's representation, you have 10 minutes.
Mr. Chairman, members of the Board of Adjustment, Dan Manning, 317 6th Avenue, Des Moines, Iowa. Representing the applicant, Kelly Wolfcool, the owner of the property at 1617 Oakland. I'll start by saying that we made a detailed presentation and representations to you at the last meeting, and I was handed this packet of information from Sue Ann right before this hearing started. So much of the information in the packet that Sue Ann has provided to you has already been provided, already submitted, already a part of the record in this case. And what I would point out, I have the utmost respect for Sue Ann, but I understand in these reconsideration situations that she works for the city, she's a staff, works for the city as well, and I think there's a significant amount of pressure to try to alter the decision that this independent board made last month. And I just simply ask that you consider that as you look at these exhibits, because they're much of the same information. Now, I'd like to go to this additional information that she has submitted. And I want to put this in context. We didn't spend a lot of time talking about this last month, but we have pending litigation because we don't necessarily agree with the staff's interpretation of how this property should function. Kelly Wolfcool purchased this property from Harbor of Hope with the clear understanding, maybe she was mistaken, maybe she's right legally. That's what is pending before the district court. So it's not inappropriate for her to continue in the status that this property had before she bought it as to the issue of whether this is or is not exempt property. It's not proof of anything to submit to you as is submitted in Exhibit 11, the status of this property imposed by the assessor's webpage. It's not something that she understands. I understand that if this body stands with the recommendation that was made last month, the pending litigation goes away, and she will operate this facility as a boarding house, and she would not be entitled to any special status if she were able to operate as a boarding house. These other references in here, and I'm kind of I started with Exhibit 11, which I think was an important item for you to consider, because it's like, aha, you're holding this property out as exempt property. Well, that's the status that it already enjoyed when she purchased the property, and that's the status that she believed she had and it was entitled to. We understand that that status will change in the event that it's upheld as the decision to uphold this as a boarding house. These other exhibits, there is no reference to 1617 Oakland as, or let me put it this way. We made certain representations and promises in 2013 that we would operate this as a boarding house. We agreed to inspections. We agreed, and we're upholding that status. That's exactly how we've operated that property since at least October, November of 2013. And this AA form, that's something that was printed. I just got it this morning. I talked to Kelly. Kelly tells me that's printed, as I understand it, once a year. There aren't any AA meetings being conducted there. And that's, that's an important factor, I think, as you analyze whether this matter should be reconsidered or not, and whether this particular whether anything has really changed since your meeting last month. I think the innuendo from the documents that have been submitted by Sue Ann is that, aha, we've caught Kelly Wolfcool doing something other than what she professed to do. And that's just not true. Now, one clarification is that on the date of this hearing last month, I believe I came up to this podium and represented that the webpage was down, and it wasn't down. Information had been taken off of the property. I didn't know it until the end of the meeting myself and talking to Kelly, and the next day it was down. So I want to be clear. Sue Ann is absolutely right that as of the date of this hearing, that one-way recovery webpage was up. A bunch of information had been taken off of it. Kelly understood that that was what we were asking her to do, and we made it very clear. I made it very clear. Take it down. It's been taken down. The other thing is to what was any sort of directive. As an independent body, I would caution you, I think you know this, but I would just simply want to make sure it's part of the record, is that we stand with the record that was made here. I was present at the city council meeting, and there was no additional information presented other than one of the former members of the Board of Adjustment, who is now a city council member, I think understanding his role, understanding the role of the Board of Adjustment, was simply to remand this back and give it every consideration as to whether this was the right thing to do. That's the only directive that I saw, the only appropriate directive that the council should be giving you, and that they did give you. But there was no underlying, we want you to check A, B, C, D, and E. And
Right.
I think that on her Facebook page, Exhibit 9, there's no reference to one-way recovery. One-way recovery is a legal entity that still exists. She's still the director of it. She's not referring to 1617 Oakland in that Facebook page on Exhibit 9. So I guess it's important from my standpoint as a person who's going to stand before you again, is that nothing has changed since the hearing last month. Nothing has changed. These documents may refer to one-way recovery, but there's not an effort to advertise, to hold herself out as operating one-way recovery at 1617 Oakland, which is the subject of this conversation. What we did submit to you last time, and what is a part of the record in this case, is that we have affidavits from individuals who have established that they send people to that site with the understanding that there is no type of correctional care. There is no type of supervised group residence being conducted there. And so we simply ask that as I recall the chairman saying last time, this is a tough call. These cases always are. This is a 6,000 square foot building that simply can't function as a single family residence. It being boarded up is not the answer. The solution that was thought through, talked through, deliberated, and that we concurred in, when we started this application, we were asking for 27 residents. We're now talking about 9. And we simply, we want to make it clear for the record that there is nothing that's changed, and that the recommendation and the decision of the board is something that we'd ask that you uphold. Do you have any questions for me?
Yes, questions for Mr. Manning. Brooke?
On the AA lane that you, where did that come from?
It was, I'll let Kelly answer that directly because I don't know, Mr. Rosenberg. But what I've been told is that it is prepared once a year, it was submitted. It was prior to the commitments that we've made to make sure that that facility is only used as a boarding house and not any sort of facility for supervised group residents. Come on up. Mr. You heard Mr. Rosenberg's question, address the board and answer the question.
About the AA pamphlet?
Yeah.
Give him your name and...
My name is Kelly Wolfcool. I live at 1306 Southeast Trilene, Ankeny, Iowa. It's printed, I think, once or twice a year at the central office. And so I haven't notified them to take my address off of the list. And that was just an oversight on my part. They're not holding meetings there.
No, I'm just curious how it was
Yeah.
distributed. Thank you.
It's printed only a couple times a year and distributed, at various sites.
Okay, further questions?
Excuse me, I've got a question. You mentioned that one-way recovery, she's still the director of one-way recovery? Where do those meetings take place, or where's the business function?
About 12 weeks ago, I took a position as the healthcare administrator for City View Residential, and I'm in the process of purchasing that business, and it's going to be one-way recovery doing business as City View. So I'm taking One-Way Recovery, the nonprofit, with me. That's just the name of my company. It's not the name of 1617 Oakland. The name of 1617 Oakland now is the house, the boarding house. There's no name. And, the men live there by themselves. I'm not even there. I'm a landlord. I haven't even been to the house.
Who stays there as the manager?
There's a house manager. His name is Brad Wood, and he takes care of everything. If they have some kind of a problem, landlord type issue, then they would call me. Otherwise, I'm not involved at all. Since this last hearing here, I have not been involved at that house. I made sure and I made clear to the residents that I cannot be involved. And that breaks my heart, but I did it.
Well, I think that was part of the requirement we had. It's just, this is really confusing to me, because it seems like there's a lot of evidence at Sue-Ann, and I'll just say, I think you inspect what you expect, so thanks for doing what you've done. And I don't know that this isn't a witch hunt. I think the information that was presented to us at the last meeting is far different than what I've seen today, which to me is pretty disappointing. Your name and everything is affiliated with an organization that had functioned there, or that you intended to function there, and it doesn't look like you've done anything to dispel that to me. So it's pretty easy to come to some conclusions that may or may not be accurate. That's just my thoughts.
Thank you, Dave. Kelly, you mentioned that Brad Wood is kind of the resident manager?
He's the house manager.
He's the house manager. Do you pay him?
No.
No, so he just stays at the house for free?
He has a reduced rent rate.
Okay. So with reduced rent then, do you have lease agreements with your tenants or
Yes.
contracts for that?
Yes.
Have you presented any of that information to this board to show how you're doing your leasing and running your boarding house?
Mr. Chairman, we did submit that at the last meeting.
Okay.
We sent a lease, we provided a copy
Okay.
of the lease that's provided.
So when they have a lease and you collect income for that, how do you report that income?
What do you mean? I file my taxes every year, and
Okay.
that's income that I would incur.
So.
I have other rental properties as well.
Right. So in running it as a boarding house, then you are, in essence, that's your personal income from that rental, and then you
I'm
pay
a
taxes on it?
landlord.
Okay. So they don't pay it to any other entity or to the nonprofit you're affiliated with or anything like that? Okay. Do you have any examples or evidence of any advertising or other notifications you've provided that these rooms are available for rent? Do you have some network of how people learn that you have a boarding house?
I actually do not advertise at all.
Okay. You do it by referrals
It's
then?
mostly word of mouth.
Okay. All right. And something Mr. Manning said, that it was your intention since October, November 2013 or so to operate this as a boarding house. Is that
Yes.
correct? Okay.
I have been steadily, working towards that.
Right. Do you currently have a certificate of occupancy for rental as a boarding house?
No, I've gone through the inspection and I was waiting for my occupancy permit.
Okay. Was that contingent on some other physical things you needed to do, or is it more contingent on?
I think it's
On this.
contingent on this hearing.
Okay.
Because everything that I have done is in response to what I was told to do.
Okay. All right. Thank you.
Mr. Chair, I have a question. There was some discussion on the tax-free status of the home. Is that still in effect? I know you mentioned that there was going to be some changes to that. Have there been changes to that?
No, on this particular property, I would pay taxes just like anyone else,
So
just
it's,
on a rental property.
so it's no longer under a tax-free
No.
exemption? So when,
Since I have owned it, it has not been under a tax exemption. Had to pay taxes,
So you've paid taxes since you've owned it?
yes.
Okay, that's a clarification then.
I went before the board and asked them to consider me for an exemption, and I did not get that exemption. I've paid taxes.
Okay, well, Kelly, perhaps you can read this better than I can, but you can see Exhibit 11 up here.
it's charitable.
It shows a negative value there that, I guess, what I would understand from that is, no, there are not taxes being paid, unless somebody can help me read that a little bit differently than what I'm seeing.
Paid the taxes. It was $1,600 the last time. I paid it. Harbor of Hope was tax exempt, but I have not been tax exempt.
And you owned it since when?
November of 2012. And I have been responsible for the taxes since that time.
Okay. Larry, do you have a comment?
Yeah, there's a few things here. One is the question of, do you have a CO for this purpose of boarding house? And what's happened with the council remand, the use variance has been delayed 30 days. So they can't get a CO until
Gotcha.
the use variance comes into effect.
Right.
And as to the taxes, of course, you don't have a tax statement, but I'm not really sure how relevant that might be, because as Mr. Maine indicated, they do have ongoing litigation as to questioning the status of being I think a correctional placement, having some rights still there, but when this does become a boarding house use, it will be taxed, and from that day, it will be crystal clear that it is a taxable property.
Well, I got a question, just for
Yes, Dave,
clarification.
go ahead.
then. At the time it was sold, the status changed from the previous owner. Wouldn't that have also affected the?
Well, and this may be.
Everything else, or is that
Sue may
just
need to
semantics?
explain. Basically, this was purchased, and I believe Ms. Wolfcole, as the purchaser, thought it had an ongoing status as a correctional placement center, but it had lost all grandfathering rights, and Sue had the determination that it was not a correctional placement center, and so I don't think there's really much dispute on that, except for they did appeal, because this did come before the Board of Adjustment in last August. Yeah, last August for that, for the request to, use variance to become a correctional placement facility. And that was denied by this board, and they have appealed that decision. In the meantime, in terms of trying to find a way that potentially could use the property, they've now applied to be a boarding house. So.
Any other comments or questions?
I guess one more question. The only thing that ties your business or your professional business to this property is that mailing from AA? Did your Facebook or LinkedIn of yours have any?
The house or the address.
Okay.
It has one-way recovery,
Yeah.
which
But-
is my organization,
Right,
and I can operate that.
but it doesn't,
Kind of a
it doesn't give the
corporate.
address or anything. This is the first time I've seen these exhibits. They weren't passed around. I don't see where there's a big difference here from what we were represented the last time, except that obviously the council sent it back to us. I'm a little perturbed that the applicant didn't get the packet of information till today. I don't think that's fair. I've commented on this several times in the past, and I don't see how they can properly present their case if they don't know what's being held out there.
Kelly, just a brief question. I'm just trying to understand the character here of what's going on at the house. Without any names or any big detail here, do you know anything, the general background of the folks who are renting from you now? Are they nursing students? Are they construction workers here on a new building renovation project? Any idea?
They're basically folks that have no place else to live,
Okay.
and they need a place to lay their head at night.
Okay.
And they work. All of them
Okay.
work. They have to work.
Okay. And you receive no direct payments from any governmental entity or any social service program? Any
Not-
goodwill grants from any philanthropy groups?
It's not allowable because I don't have a
Right.
occupancy permit.
Okay. All right. Thank you. Okay. I think at this time, unless anybody's got any other questions, at least for the time being, we'll go ahead and hear from some of the other folks here that may have some comments on the request here today. Thank you. Is there anybody else here to speak in support of the appellant? Sue Ann?
Chair, if I could
Yes.
correct one thing, it does
Yes.
appear that she paid September's taxes in the spring of this year. So she
Okay.
is paying real estate taxes.
Okay, so
Not
even
sure
though
why
the-
it's listed on websites
Right,
as
right.
tax exempt, but I wanted to clarify.
Right,
that.
and we realize sometimes what the county shows isn't always the same things that the city's concerned about.
Yep.
So there are real estate taxes being paid at this property. Okay, thank you. Okay, anybody else here, or is there anyone here to speak in support of the applicant? Is there anybody here to speak in opposition to the applicant? Okay, you'll have 5 minutes each for any comments. I would suggest, if there's more than a few of you, just to line up against the wall here. And again, we'll need your name and your address.
Mike Hildebrand, 410 Franklin Avenue. I'm a resident of the Riverbend neighborhood. I'm also on the board of directors. First thing I would like to ask, if it pleases the board, can I
Yes.
avoid having every one of the residents that took time out of the day to come up here and speak, to just raise their hand for recognition and avoid all of them coming up to speak?
If they're interested in having you speak for them, they can certainly raise their hand. Okay.
Thank you.
All right.
Secondly, I received an email from a resident that couldn't make it today about
Sure.
2 hours ago, and I'd like to submit that if that's at all possible. I made copies as well as, I got 9 copies.
Are these all the same?
Yes, they are. And I would like to, if possible, clarify a position that I held at last hearing, because I think it directly impacts
do.
this hearing.
Okay.
I was asked what I thought should be done with the large structure.
Right.
I do take exception to it could never be a single-family home, but we're not going to debate that.
Okay.
We're on different ends of the spectrum there. But what I said at the last meeting, whenever I was asked by one of the commission members, I made a statement off the cuff, no research, of personally, I thought I did well clarifying that was my personal opinion, and that personally this is what I would consider. I thought I did a good job of that, but at the end, whenever the decisions and discussions were being made, that was brought up. And so I want to make sure that that personal opinion was no research, my personal opinion, and does not hold true today. Because I would expect that I would be treated no different than any other resident in our neighborhood. So if the neighborhood opposes rezoning or variances for this individual, I guarantee you they will oppose it for me. So anything that I would plan to do with a facility like this they would be consistent. There would not be any favoritism or any, well, Mike wants to do it versus Kelly wants to do it. So what I said I wanted to do would not have fallen underneath the R160, so that would not have flown with the neighborhood.
Okay.
I think we get on a slippery slope if we start making exceptions for people who've made bad business decisions or poor judgment or just didn't understand what they were getting into. We'll have a smorgasbord of zoning and use in the neighborhood. and we'll start chipping away at the years of work that our neighborhood association as well as the other commissions and boards have worked on. So I think we need to be careful with that. I have as much compassion as the next person, but I don't think we can base decisions on feeling badly for somebody making bad decisions. I guess the final thing I'd have to say is, I think it was very apparent here today with what Sue Ann presented. Kelly is, I'm certain she is a great person in the treatment facilities. I can't really question her business abilities, but I think it's a sort of a common theme that Kelly doesn't focus on the business aspects of things, and there's a compliance issue for the past 19 months. I don't expect that to change, and I think it'd be a disservice from this commission to grant something and pile more restrictions and more requirements on top of that, because I think it's setting Kelly up to fail. So that's why I personally, as well as speaking for the Board of Directors, the Riverbend Neighborhood Association, supports the R160 zoning of the property with no variances. Thank you.
Thank you, Mike.
Questions?
Yes, any questions for Mike? Okay, thank you. All right, who's up next?
My name is John Larson. I live at 306 College, and I guess you said a lot of stuff that I was going to say, but I was just going to let you know that since this has been going on and there's been a lot of shady activity at night going on, and I have kids, and if this goes through, I'm moving. So I just want to let you know I will be gone. I'm not in favor of it. So.
Okay. Could I have staff put up an area map? So John, could you show us where you live in relation to the property in question? Thank you, Sue Ann. Just maybe that consent map would work. Can you point to where you live?
Right here.
Okay, where the red is.
And that's
Okay.
right where all
Okay.
the activity comes, and everybody that comes down that driveway, and
Okay.
I got people lurking around at night, and I'm not going to put up with it.
Okay,
So
all right,
I will
thank
be
you.
moving. So.
Next.
Hi, Carolyn Jennison, 1330 9th Street. I have been a resident of Riverbend for 15 years. The great people that have joined me today are many of the people that I talked into moving into our neighborhood, and many who have been there before me. What we did was, when I came into that neighborhood, there were a strong group of volunteers that had we worked together to make the decision, not based by city, but we chose as residents to change the zoning to R160 to protect our investment. We did that, we walked the streets and made that happen. As representatives of your citizens, we ask that you honor that. This new group of people have gone even further and turned it into a local historic district. These were improvements that your residents made, not you, your residents. And so you honored those. And so what I'm asking is, 10 years ago, I sat in this room, and another individual came in and didn't do their research very well, or did, but we're going to ask for forgiveness and not permission. She asked for permission. We guided her. And I'm going to ask that you not have us sit here and do this again, for you to not honor that group of individuals that have worked so hard for one person that doesn't even live in the city. So I'm asking you not to repeat history. I'm asking that you carry forth your duty to represent the citizens of our city and honor their work and their desires to continue to improve our city.
Thank you, Carolyn. Mr. Thompson.
Roger Thompson, 2000 Ninth Street. First of all, I'd like to apologize for my appearance. I just found out about this right at 1 hour ago.
You're talking about your
At
shirt,
work.
right?
Yeah.
Okay.
I have been involved in Riverbend for 18, 20 years, way long. And my point in the neighborhood has always been law and order. We have to have rules as a society. You look at the inner city of Des Moines, and you see one neighborhood stand out with a low crime rate, and that's Riverbend. That's the work we have done. I feel sorry for this lady that didn't do her due diligence, but for her to do due diligence doesn't give anybody the right to victimize the people in my neighborhood. It's my understanding there's been a lot of rule violations. Even when called on it, there was more violations. If this goes through, I don't think rules mean anything. Thank you very much.
Thank you, Roger.
Laura Hanson, 1828th Street. I just wanted to comment on, it's been brought up about the square footage of this residence and some concerns about what could it be used for. Certainly there are properties in Sherman Hill of large square footage. We have houses in Riverbend that have been converted from apartments housing 12 people into a residence of 4,500 square feet with 2 residents. I think that there's been great strides in Riverbend. I've lived there for 10 years now. It's an awesome group of people working together to really improve this neighborhood. And when I see the downtown and the East Village neighborhoods and the housing boom and the apartments and the condos, I wonder then about those young people then when they start to be looking at houses and for families, is it unreasonable that a family might not want with several kids to have a house this size? Or what is happening with the zoning is I want to stay in Des Moines, but I can't because I can get a big house with big square footage out in the suburbs. And I think it's really does a disservice to say a house like this needs to be turned into a boarding house or it has no other use. I certainly have concerns and would reiterate when we have an individual who has not been compliant with what the board and the commission has asked her to do and is a constant cat and mouse game, frankly, I certainly don't want to be the neighbor that's putting up with that. And I ask you to think about, is that the kind of neighbor that you would like to have next to you with now what's being proposed as a boarding house with 9 residents? Thank you.
Thank you. Yes, sir.
I'm John Royal, 1838th Street. I live in a house built by my great-grandparents in the neighborhood. And my mother was one of the founders of Riverbend who sat on the street corner with the prostitutes to chase off the Johns. So I've gone through being a very nice middle-class neighborhood to being a pit to coming back. The new zoning has been one of the things that's helped in trying to recover our neighborhood to back where it can be nice, comfortable living. When my children lived with me, and I was divorced, they lived half the time with me and half the time with their mother. When my son turned 14, he could no longer have his friends come in from West Des Moines because their parents wouldn't let them because of the neighborhood reputation. So we're talking about real things about attitudes and stuff like that that happen in terms of communities, and we have been overburdened with density of population for a long time. We've been trying to correct that problem and move back to a reasonable balance. We are the most diverse neighborhood in the community and very proud of it, and we work well with that. So it's not about not wanting diversity, it's about wanting balance in that process, and we have a difficult time maintaining that. Additionally, it's about economics. I have a house built in 1887. It needs a new furnace. My furnace is 60 years old. It needs a garage. I'd like to build a carriage house so it was consistent with that. All those sort of things. My house in West Des Moines would be probably $350,000. It's $112,000 or $120,000 on the assessed value. When I try and go get a loan to try and do those sort of things, then I get into problems with that. So we're talking economics here of how do we increase the neighborhood and value the neighborhood when we're taking the projects and making undervalued because we're taking care of somebody else's business decisions. So it has real impact on us as people to try and upgrade the neighborhood. So thank you.
Thank you for your comments.
Good afternoon. Brian Bai, 523 Franklin. I sit on the neighborhood board, and I also am a commissioner for the Historic Preservation Commission. First of all, I also do not support, well, I support maintaining the zoning that is today, and the consistent compliant issues also from the local historic district perspective, not going through the proper procedures to do that, and then, oh, okay, I guess I have to do that. So all of that aside, there is still, we heard today that there was nothing linking the house with one-way recovery, the address linking one-way recovery. I pulled it up on Facebook. I'm happy to show it to you. That's probably, let's just pass it all around.
They might be able to focus again.
zoom
Can you zoom?
Here we go.
There we go.
Okay, One Way Recovery, nonprofit organization, 1617 Oakland Avenue, right there. So there's a description of the organization attached to that site, which was misrepresented. What's that?
What was that on again? What site?
That's on Facebook, where it is being advertised as a nonprofit organization. For many of us, it is much more important than a website. It is a way to communicate in ways that websites aren't. So, again, just continued frustration with misrepresentation of facts, and I would encourage you to deny city staff's recommendation.
Yes, sir. Go ahead.
Good afternoon. My name is Aaron Tide. I live at 803 Hickman Road. I'm also on the Riverbend Neighborhood Association Board, also serve on the Historic Preservation Commission. But my main point is that this has taken up a lot of people's time. We have worked really hard to make changes in the neighborhood, one of those being rezoning, one being local district, and others. And we really need them to be enforced in order for our neighborhood to take the next step. As residents, you can see how committed we are to this, that we've spent 18 months dealing with this issue. And every time a decision is made, something has not been followed, and the reason why we end up back before boards and commissions and back before city staff is because something's not being complied with over and over again. It's a pattern that's been repeated month after month. And so if we don't go back to what it's supposed to be, we're just going to keep doing this over and over again. We're exhausted by the process. I'm sure she is as well. But we're tired of chasing compliance. And we would like this to be settled. We'd like it to be the right decision, which is the policy that was set by council.
Question.
Yeah.
Were you at the last meeting? I don't recall.
I was not.
I only recall one of the gentlemen at the last meeting. Can you tell me why there was such a crowd today and not at the last meeting?
I think just the word has gotten out that we should be having more people at meetings. So we spent a lot of time discussing and deciding strategy and communicating with council and communicating with staff. And when meetings are at 1 o'clock in the afternoon, it's pretty hard for people. I personally work for the legislature. Until we adjourn, there's no way I can make these meetings, even evening meetings. So my schedule is now free. The communication is out to the neighborhood, and so we're showing up.
There was the same communication that went out the last meeting. I'm just
It's one of those things where it waxes and wanes. So 18 months. How many meetings? I mean, we should count up how many times we've met with staff. We met with Kelly a few times. All the communication. Eventually, like, I'm not going to another darn meeting. We've had enough. So you end up at just different points where we have more people showing up and fewer at other times.
Okay, thank you.
Thank you. Anybody else to speak in opposition? Okay, before we give the applicant a chance for rebuttal, I would like to ask Sue Ann a question or two. I'll give the appellant a chance to comment on anything mentioned here. Sue Ann, they need to have an occupancy certificate, an inspection certificate, correct?
They'll need a rental certificate.
Yes. They don't have one now?
They have the inspection, but until
Okay.
the zoning determines what it's going to be through
Right.
these processes,
Yep.
we're holding this rental certificate.
So how are people allowed, she has leases, she has tenants, people live there, how is that allowed to continue? Is there some continuance from something before? Or is that just an assumption on their part?
You have two different code sections in play.
Okay.
You have Chapter 134, which is the zoning part of it.
Mhm.
We have Chapter 60, which is the rental inspection.
Right.
We filed a civil infraction in the rental inspection
Yes.
side.
yes.
We got an order to vacate.
Right,
She didn't. We did an
Okay.
application order show cause why she shouldn't have to vacate. We entered a consent agreement with her, which is in the packet of materials,
okay,
saying that she had 60 days to vacate unless she came to the board for
got it.
a use for a boarding house, and proved to our satisfaction that it wasn't being operated as a supervised group home. That 60 days lapses tomorrow.
Okay,
If we're not satisfied that she's operating it in compliance as a boarding house, we will go and ask for the writ of removal.
okay. So kind of in a way, they are allowed to be there at this time,
Till tomorrow,
till tomorrow, okay.
and then we'll have to decide, based on the information that I've found, I'm not convinced that it's not being operated outside of the confines of our agreement, which was a boarding house.
Okay, all right. Thank you. Okay, since I got Sue Ann up here, any questions for her? All right, thank you. Okay, applicant, you've got 3 minutes for response rebuttal.
Mr. Chairman, members of the board, Dan Manning, 317 6th Avenue, Des Moines, Iowa. I guess I'd like to just, from an overall standpoint, when this property was purchased in October of 2012, Kelly purchased the property, put approximately $60,000 in the property. The property has never, since Harbor of Hope was in the property's never looked better. We've allowed the city in to inspect it. They say the same thing. I've asked Sue Ann Donovan to come and take a look at the property to see for herself, because the standard that we agreed to was that she'd have to be convinced that we're not operating the property since the fall of 2013 as anything other than a boarding house. The information is provided to you. The only additional information is not proof that anything has changed. We're representing to you that nothing has changed. I say nothing has changed since the fall of 2013 in terms of how we're trying to utilize this property, and that is as a boarding house. It's the only thing that I've heard anyone say, and from our perspective, is that, you know, we certainly respect and understand that the Riverbend folks want and have worked very hard to improve this neighborhood. We see the effort by Kelly is to improve her home, which helps improve that neighborhood. And we believe that the decision that was made last month was a sound decision that would be beneficial to the neighborhood. I can only emphasize again that the effort being made to operate as a boarding house is something that we took seriously when we made the promise to Sue Ann that we would operate it that way. Nothing that's been presented changes that. You may ask a question or two as to why do we still have these lingering references to one-way recovery, but we're not operating it that way. We asked that certain representatives of the Riverbend neighborhood come and inspect the property with myself and Kelly, and I believe they took us at our word. They didn't want to inspect the property because we were living up to the representations we were making. We simply suggest to you that simply because this matter was remanded doesn't require a change, that the decision that was made was a good one, good for the neighborhood and good for the property owner. And by having a property that they can have some income from, they can continue to maintain their property and keep it in the manner in which the neighbors want it maintained. So we would ask that the decision be made to support last month's decision of this board.
Okay.
Thank you.
Thank you, Dan. Any other final questions for Dan? Okay. Sue, I have another question for you. I think this is just a brief one. I don't think this will surprise Mr. Manning or his client. If we were inclined to approve this, subject to the staff recommendations, is that like a 30-day clock? If we approve this and they don't come up with a rental code inspection certificate required by Chapter 60 within X time, does the whole conditional use permit then expire?
They have 2 years.
They have 2 years.
The condition, unless you put a.
Other conditions on it?
Condition for time.
Okay. Larry, do you have something you'd like to add to that?
But Sue, it'd be fair to say they couldn't occupy it legally until they got that rental certificate, even under the use variance.
That's what I'm getting at.
Correct.
Okay. So how soon, yeah, so she wouldn't be able to, until they get the rental certificate, they could not live there per se, but they'd have up to 2 years to get all that figured out. Am I
Well,
correct?
we have an order under
Right.
Chapter 60 to vacate unless they prove to our satisfaction.
Right.
It's being used as a boarding house.
Okay.
I believe we're ready to issue the rental certificate.
You are, okay.
Because
all
they
right.
passed inspections.
Okay, all right,
So it's just the logistics of what they are
okay.
at this particular
All
point in
right.
time.
Because whether this fails or passes, if it would be inclined to pass, I'd want to know that we get something and the place gets moving and things look good, and we've got a way to then measure and meter this going forward.
I would also, I believe that staff recommendation, although I don't have it in front of me, authorize the zoning enforcement officer to bring it back to the board.
Yes.
Should there be a belief that it's not being occupied as a boarding house.
That's item 5, the last condition,
Correct.
yes.
If
Okay.
you approve, if you reapprove what you approved last time, that would still be in place.
Okay, thank you. Okay, I think we have followed our due process for input. Now it's time for ours. So we'll close the public portion and go to board deliberation. I need to have some good discussion on this.
I was opposed to this 13 months ago. I was opposed to it every single time that it has been brought before us. I'm opposed for it today. I am so happy that the city council asked that this be brought back, because I just believe that we needed to hear the additional information. We have, thankfully, the neighbors were here today, but they have investments in their neighborhoods. We are all about listening to what neighbors want and what is best for the neighborhood. And to have somebody have a boarding house that's managed by somebody who gets reduced rates to live there. I remember looking at the police reports last month. There have been police calls to that residence for different things. It's not an appropriate place. It's not meant to be a boarding house in that area. This neighborhood, that house could be fine as a single-family home. Yes, I understand that you'd have to come in and do some converting, but ask the neighbors that have lived in that neighborhood. They have spent thousands and thousands of dollars in their neighborhood to make it better. Even if you don't take into account any of the dollars that have spent, our time is precious these days. Our time is worth a lot. And when you have a neighborhood that has spent so much time working on something to make their neighborhood so good, it would just be an injustice to let this happen.
Okay, thank you.
I urge my fellow members to vote against it.
I would concur with Linda, and I voted for it last time, but in hearing all of the new information, I'm a bit remiss in thinking that things would change according to what she says, how she says they would change. And there was a comment made by the applicant's attorney that, you know, this is good for the neighborhood, and I don't agree with that. And maybe it's good for the owner since she has invested some money into this property, but I think there's other uses for the property. And I just don't see it as good for the neighborhood. And I appreciate everyone's comments today from all sides.
Okay. Gentlemen, anything else?
No.
No, this is discussion.
So we could
I
have a
move
motion.
staff.
Okay. Larry, hang on just a
Before
second.
there's a vote, I'd like to speak for a minute.
Yes, yes, okay. Dave, any final thoughts?
No, I'm just, I'm confused. Based on what I'm told and then what I see, and 15 minutes ago, I'm showing a Facebook page, and I'm told that there's nothing that's connected to this one-way recovery, and it's right there in black and white. We're told by people that it's not being operated the way it is. I just have, I've got some real empathy for the residents around there, because I think this is a tough deal, and it's, I'm trying to put myself in their shoes. So we've all got to vote.
Okay, thank you, Dave. Larry, do you have something you'd like to
Yeah, I'd
add?
just like to mention a couple things. These remands are relatively rare. They're just slightly different than what we do.
Here, let's put you.
I'm sorry. Basically, the city council remanded this for further study by the board. And that's what you're doing here at a hearing, further study. The council remand did not extinguish or terminate the existing variance. It simply delayed the effective date of that variance for 30 days so this board can act. So the actions before the board could be either to uphold the previously given variance or overturn or extinguish that variance as an alternative motion. And any of those motions would only require a majority of this group, three to five, because basically, they've already have the approved variance on a four-person vote. So the uphold or the overturn could go on a straight majority. If no motion passes, the prior variance will be approved after 30 days.
Okay. So if we vote to overturn the decision from last month today, then with that vote to overturn it, it then fails and the use cannot continue. Is that correct?
Correct. And that would
Okay.
be the case.
With a
because
simple majority.
Yeah,
here.
in original variance, that would be the case too. No could be done by a simple majority.
Okay. Yeah, all approvals for something would take 4.
Right.
Correct, okay.
Right.
All right. Okay. We do have a motion on the table. I try to give people the benefit of the doubt when I can, with evidence provided to support their positions and their opinions, just the way that I approach these things in accordance with the variance standards we have. But when this was remanded to us for further study, and then I hear more information and I see more things, and I see more connections, whether they're real or perceived, they provide me with concern about the neighborhood, concern with compliance with the criteria that this board does have to consider. And when I see on a Facebook page that I know Facebook is something you can update at the moment, to think that this nonprofit, this Recovery in Action, which supposedly we're disconnecting ourselves from, is still being addressed as 1617 and probably has been updated recently. It's just kind of amazing how technology provides us with more opportunities, but also more evidence, and sometimes a trail that goes back to what's really going on. Whether it's intention, whether it's perception or not, I'm seeing too much here that tells me she has not separated herself from this property and what her intentions are. I just have not seen enough here to, in good faith, with this further study, I haven't seen any new evidence that we're running a really nifty little boarding house and we put an ad in the Drake newspaper, or who we have here. Apparently we have people with nowhere else to live, probably with very little income, and they're just kind of showing up here. That's really not what I thought a boarding house was supposed to be about. I thought you put an ad in the paper or you're somehow marketing this thing. If you're running through word of mouth and that's all we have, I didn't hear anybody who is a resident speak today. Usually that carries a lot of weight for me as well. So with what I would consider to be new information provided, I have some difficulty in further supporting this. So we do have a motion on the table here.
Is there a second?
Getting to that. We do have a motion on the table here. Is there a second for that? Okay, that motion is to, did you motion to approve it, Brooke?
Motion was to move staff.
Okay,
And that's to
I'd like to get a vote before 5.
Okay, all right. We're just going through the due process. I try not to say anything we don't need to. Okay, we've got a motion on the table. Do I have a second? To approve staff. Okay, motion fails.
I would make a motion to overturn the previous decision made by this board last month.
Do I have a second for that?
I'll second.
All those in favor, raise your hand and say aye.
Aye.
Okay, that motion carries 4-1. I'm sorry, Brooke, you didn't raise your hand, though. I apologize. So we have 4 that are voting to overturn? 4-1? Okay. All right, thank you very much. Okay, that's item 9. Let's move on to another item, item 10. I'm gonna duck out very briefly. If you miss this, 60 seconds. Yeah.
Did he turn the chair over, or am I waiting for? Okay, I'll wait.
Jesse duck out for
Yeah.
seconds.
I didn't think I heard it.
You didn't tune it over.
Okay. Just wanted to make sure that you weren't waiting on me. Mr. Chair, members of the board, this item is a continuation from the March 26th and April, is it? It's just from March 26th, wasn't it? Yeah. I think it's just from March 26th, 2 months ago. And the basic, I think, request by the board at that time was to get some clarification on how the appellant had interacted with the Parks Department in seeking opportunities in the Grandview Golf Course and Grandview Park areas that are just to the north. And again, the subject property is in the gold outline here. Areas that would be in the park are just to the east. They would continue all the way to East 33rd and then north even another block further into the golf course. There is a significant terrain change as you go north and to the east where the terrain rises to some extent and then begins to fall again. The RF engineering provided, actually at the previous hearing, indicated that points on the golf course that were being looked at didn't provide the sufficient coverage that was represented by the appellant. One of the things that was asked then was to look at areas further east to this property, which might, the appellant indicated that might be something that was workable from an RF standpoint. They've since come back and met with the Parks Director and indicated that the locations to the east here that we're going to work from an RF, and RF stands for radio frequency. It's a kind of a lingo for the engineering of the communication signal. And if you have any questions on that, I would think that you should ask the appellant to explain that. But they provide the coverage maps to us using a propagation software. But they had indicated the only location to the east that was workable from an RF engineering standpoint was near this historic entrance area. That was not an area that the Parks Director was willing to consider at this time, just from a character perspective and impact on the users of the park and the historic nature of the park. And I believe he's here today too, if there's any questions for the Parks and Recreation Director, Ben Page. So there should be a letter in your packet, or that was included or handed out, that was from Ben Page. And then there's also a revised statement that was sent from the appellant on the letterhead that says Buell Consulting, I believe. It should be in your packet to reflect, based on this being strung out over a series of applications and meetings. I think they wanted to ensure that you understood their current position on all the matters. From staff's perspective, we looked at this, and we've maintained and held that the initial application made, or the most recent application made, satisfied the criteria that the board is charged with reviewing and upholding in granting such a request. In looking at this to comparable facilities throughout the city that exist and operate, we believe that they sufficiently demonstrated meeting those criteria. From that standpoint, you're able to listen as a board and put further conditions that you believe are necessary to achieve those criteria. Some things you might hear are looking at alternate methods of camouflaging or integrating or minimizing the impact, visual impact, as an example, where you could put additional conditions to what staff has recommended and still grant the request. So I want you to understand that the board has some ability to place those further conditions based on the testimony you hear from neighbors and questions that are brought up. Certainly, we've basically determined, other than the golf course, there really isn't any other properties that would meet what they call their search ring, or to provide the RF engineering that they need, that are of that 10 acres that's the requirement in the R180 zoning. So it has been pointed out that this location here is smaller than another property that would be closer to the 10 acres, which is the hospice site to the west. And the appellant has indicated that that was a negotiation they were not able to make happen, and has put that on record at the hearing. And so from staff's perspective, we are taking that statement at its face value. And so we still believe that granting that approval as presented would follow the criteria necessary to grant this. And we're recommending approval, and we haven't revised the conditions from the previous hearing with the 11 items that are outlined in the staff report. One of them is that if there's some issues with how this is operated, or this becomes a nuisance, if the backup generator becomes too loud or high impact on the neighborhood, that there's the ability to bring this back and revisit the consideration. I'm sorry, I'm looking at the wrong staff report. I'm sorry. Cancel that, what I just said. I apologize. Looking at the wrong line. The 5 items on page 37 are what we recommended. And one of those was the signed lease agreement. We do have a signed lease agreement. I do want the appellant to provide some explanation as to how that complies with our provision to remove the structure. I think there's an item 14, but I want to make sure that this condition is executed at the time before we issue a permit. Right now, we tend to get unsigned versions of the lease or redacted versions of the lease, and there is a point where we do want something that actually is in force. So that's why we have that condition in there. We do also want to make sure that there's any shelter that would be for a second carrier meets all the character and design and materials as the initial equipment shelter. They're not really demonstrating exactly where that would be located or how that would occur. We generally review co-locates on an administrative level so that we would ensure that it met the same level of design and construction and compatibility with the main church structure that we are seeing in the proposal. And it'll be argued that there's no requirement compelling the applicant or the carrier, the tower owner, to allow any second carrier on it. They can design it to accommodate it and still not allow it. From that standpoint, that this having the second co-locatability gives staff leverage when we have other requests from other carriers, that is an approved option for a secondary co-locate. And we could actually deny another applicant for another location based on the fact that this may be available. They would have to demonstrate that that was not a solution for their network, for example. So even if the church never chooses to lease to anybody, it gives us some leverage to reduce the impact in the area as a whole. So, and that's why the original requirement was put in the ordinance. So I did want to point that out as well. I can go through photos again. I don't know if you've seen enough of this, or I don't want to prolong the presentation, but I do have that available if you need to see it. At this point, it's still, the rendering is shown is what's being proposed. It does have the cross element on a stealth pole design. From a staff perspective, we believe that meets the intent of granting the conditional use. However, if the board has other ideas or concepts that they believe also would achieve that, staff is not locked into this exact design. I think we're comfortable with anything that the board feels is in character and meets that criteria. So that's just what's being proposed. That's what we understand the church has approved, and so and we believe that meets the criteria. So that's what's still on the table at this point. Any questions? I can show you the.
I have some questions for the parks director.
Okay, and I'll just have the chair call him up then at whatever opportunity.
Okay. Brooke, you got your microphone on over there? Okay. All right, so before we get to any questions for others, any questions directly for Eric before he steps away? Going once, going twice, okay. Okay, as part of staff presentation, since we do have a letter on the table here, and Brooke, you'd like to hear from Mr. Page and ask him a question or two, is that correct?
Yeah.
All right, Ben, there you are.
Chairman Pence, members of the Zoning Board of Adjustment, I'm Ben Page, Director of Parks and Recreation.
I'd like to know why you couldn't work this out, since in my opinion, it would be the best route for the city to bear this burden versus private property, and with the input from the neighbors, why you couldn't come to terms both financially, which I'm a little confused on why the financial aspect would be a big issue negotiating with the city. And I understand in your letter that had to move some things, or it could impact some of the trees or whatever. But I would think the city would bend over backwards to try to accommodate something like this versus having to put it on private property.
Some great questions. I can first hit the financial consideration piece. We never got that far down the road because there was never a location. Financially, I think we were open to whatever we could negotiate that met the best need, as well as the current fair market value of this type of arrangement in city parks. But I have a few maps, if I may, to illustrate how we started.
Please do.
So, if you will, it's kind of quite hard to read, but you see the footprint of the golf course is in gold. And you see the park is right here. When we first became aware of the situation, that there was a desire to place a cell tower in this area, we looked at this site, but we also said we'd step back just to make sure. Again, we didn't understand their business, but we understand we had a lot of land that was managed by Parks and Recreation for the city. So I had my team and myself look at just the region, if you will, of park spaces. Again, it's kind of very difficult to see, but I started down here, which is called East Town Park. It's also a softball facility. We thought, ideally, that would have been the best site if the city was going to figure out this, because that softball field is lit. It has large light poles. It kind of could have blended in. Upon some discussions with the siting company, that was too far off of their path. But you see, we own several properties in the area, so we started zooming back into Grandview Park. Again, trying to accommodate the need. We said to them, okay, right there is Easton Boulevard by my finger. That was the desired location. I said, you know, that's the historic entrance. That park will turn 125 years old in about 2 years. One of the first 4 parks the city purchased. And that's your front door. As you know, when these things come in, it's just not a pole. I will tell you another graphic here. This is again provided to us by the siding company. This is what also goes with the pole. You have a building, you have a fenced-in area, and you have, most times, little 1 or 2 parking stalls off the beaten path. So that would be a pretty huge impact to the front of our front door of our park. I mean, when you go to parks, you look for the majestic view of a park. So you said, again, we could probably still figure this out, but just not there, in my opinion, as a staff member. I just can't recommend we put that at the front door. So back to the map, we showed them a few other locations. We showed them the corner down here by our tennis courts. Again, not that far off geographically, but we were told that wouldn't work for their business. I also liked a little site on East 33rd, right where the golf course starts up here. We have a little back of house operation where we keep our dirt and compost for golf course operations. It's kind of tucked around the corner. As you can see, only a few houses across the street at least. We thought we could tuck it back in there. Again, that wouldn't work. We showed them several other properties. Again, that wouldn't work. So we finally said, is there any site in this big, large acreages of parks we own that would work for you? He said, if I can't have the front door, then I can't work with you. It wasn't a personal thing. My engineering says right here or nowhere else. We tried, we just can't find a spot that, in my opinion, would impact the park, the trees, the disc golfers, the public's use of that facility. Does that answer? Can you leave?
Yeah.
Yeah, sure can.
Thank you. I guess one other thing, it wouldn't work because of the coverage area, is that, or should I ask?
That'd be better for them.
Okay, thank you.
Thank you, Ben. We appreciate that graphic, too. We may need to refer to that here later. Okay. Okay, applicant or representative of the applicant?
Good afternoon, Mr. Chairman, members of the board. My name is Kurt Walter, live at 2897 Lake Vista Drive, Northwest in Rochester, Minnesota. Do represent Verizon Wireless on this project of ours. Try to make this as brief as possible. It's been a year now since we originally applied. We discussed this last year, a couple meetings. Decided that we should talk to the park board after talking with the board here and some of the members of the residents nearby. We did that over the winter, came back here 2 months ago, said, here we go. Talked to the park board, talked to city real estate people, financial terms, where we can go, where we can't go. We're all the things that Mr. Page has demonstrated today. Didn't work out, came to you guys, said, hey, this is what we're looking at, these are the coverage maps, this is what does work, this is what doesn't work for us. Some more input from the neighbors saying, hey, we've talked to the park boards, we get a different story. We've taken 2 months off, made sure that we've fully looked at everything between Verizon and the park board, and we have gone over items. We'll start off here real quick. We believe we've demonstrated what we're looking to do. We are, in some of our original documentation last year, our goals are to cover the area better and to offload other sites that are basically, in layman's terms, getting almost to capacity. More people using smartphones, more people using internet on their phones, all that stuff takes up so much bandwidth. Each space has to be offloaded, basically. Here's the existing coverage, as we've demonstrated before. Our location is right here of our proposed site. We've demonstrated that the AT&T tower that's off at Mecca doesn't give us as good a coverage as this site. See the green and the black are not as good areas. This covers our objective, the topography of the area. Most people get confused. We need the highest point in the world. That's not it. We need to be where the technology is being used. We've gone to the golf course area. If I can borrow one of Ben's pictures here. We've demonstrated that this particular area of the park would work for us because of this coverage. It gives us pretty close to our proposed coverage. It's not that far off. Talking to the park board, this area really doesn't work. Here or here works for them. Golf course coverage from this location here, as close as possible behind some sheds that they've got, still leaves us some gaps along Easton and along Hubble there. We've demonstrated that if we move down close to Kmart, now this is different colors on these two particular maps because they were done at a different time. But here's the existing coverage with different parameters that were used last year. And then this is the coverage with the Kmart spot, which is very close to that other park with the softball fields, compared to the coverage with our proposed Presbyterian Church location. We have taken into consideration a lot of the comments from the neighbors. We believe that this particular style of cell phone facility would blend in really well with a church facility. We've built many of these. This particular style, bell tower style, different styles we've done before. This one fits here, we believe. We've taken there were comments about the generator that we have. We've changed that from a diesel generator to a natural gas generator. The hospice next door, just a few hundred feet to the west, has a generator similar to ours that we're proposing that no one seems to doesn't seem to bother people. It'd be very similar to that. We've looked at, people commented that we'll be looking at this shelter. It's going to be matching the same existing brick of the building. We're going to be planting some shrubs and some screening in front of it on both sides of it, so you won't be able to see it as clearly from the street. or from the houses behind it to the north. There's no really getting around not seeing the 120-foot tall structure. It's hard to camouflage that. I know there was comments about pine trees and that kind of thing. Problem with a pine tree is it's more stuff. If it snows, then we have to cover it. There's certain requirements that a pine tree will be much more large and beefy, and I think more intrusive in this type of facility. We do have some of our engineers here that can answer any coverage capacity questions that you might have that you don't fully understand with our propagation maps. Other than that, we're doing the best we can with what we've got. The only real difference here is there's not 10 acres. In the coverage area between where the golf course doesn't work, Kmart doesn't work, and the AT&T tower doesn't work, in that particular area, there is nothing there that is 10 acres. So nothing will work other than the park, and our discussions that where we can go in the park to make it work, doesn't work for the park board. So.
Okay. Is that your presentation, Kurt?
Yes.
Okay, we have some anxious questions here. Ladies first. Cindy?
Oh, thanks. Hey, Mr. Walter, if you don't mind putting the map of the park up again, and you had pointed to the area, you kind of had placed your hand over the front entrance area that showed that it extended all the way to East 33rd and Easton Boulevard there by the tennis courts. I thought I heard Ben say that there was potential for placing it in that area, but you're saying that that's not workable?
The tennis courts themselves have small playground for small children. We don't like to put these items on elementary schools, anywhere where there are small children playing around. In the winter, as freezing rain gets on this, there are some falling ice concerns. We don't like to do that at all.
So does this mean churchgoers take their own risk as they come into worship?
Yeah.
I mean, it's right by the front door. Yeah. Okay. Brooke?
Mr. Page mentioned that the only spot you thought would work was right at the entrance. Is that correct?
Not exactly. In that general vicinity. We've been, I don't want to get in the way here. Basically, anywhere south of Thompson Avenue works really well, would still work for us. So basically this area right there, that's what we looked at.
So any area south of Thompson Avenue down to Easton is workable?
Roughly, yeah.
Roughly.
It'll give us.
But you and the city couldn't come to an understanding?
From my understanding, and I believe what Mr. Page has mentioned, that he couldn't support something in that area. I don't want to put words in his mouth, but I believe.
All right.
Okay,
thank you.
This would be a perfect spot up here where the park board would like. It just doesn't help our coverage at all. I mean, there are great spots, commercial buildings, that kind of stuff that would be a great spot for these. It just doesn't happen to be where we can use the coverage.
Right. Okay. Kurt, the proposed height is 121 feet. And I'm not sure if height is our issue here or just the, proposed location of it. But with the height you have room to co-locate on this.
Correct.
Is that correct?
Correct.
And based on agreements, FCC, et cetera, do you have an obligation to allow other carriers then to co-locate? Or is that just kind of an industry handshake thing?
We have master lease agreements with all the major carriers.
Okay.
So if AT&T wants to come and use this, we've
Right.
already got an agreement
Okay.
already set up with them. US
Yeah.
Cellular, T-Mobile.
Yep. If we knock the height down another 20 feet, could that impact your ability to facilitate co-location or your own coverage?
I can let our engineers discuss the coverage part. We need to be above the tree line so that we can get out there. Leaves and trees do have an impact on what covers, but I've been informed that if we dropped it 20 feet, we wouldn't have the coverage that we need.
Okay. And for co-locating, there's certain boxes and transmitters and stuff, others have to have room to install, so you need some vertical room for that too, right?
Yes, and we've provided that here. As for the shelter that Eric or Mr. Lundy has discussed, we're leaving that up to the church themselves. When a new facility comes in, the technology that they're going to use might be different than today's technology.
I got you.
Depending on what they use, we can put, sometimes you can put the shelter 300 feet away and run fiber line up there and be fine. Some of them you can't, so it depends on the technology.
Okay.
So we could put something on a roof that's going to look like, large, air conditioner facilities on the roof and then attach it to,
Okay.
We can do a number of many things.
And since you mentioned it, the way you are designing the kind of the shelter per se, do you have some room in there now with current technology to allow for some expansion or co-location of other carriers then?
We don't put anybody else in, nobody else has
No,
access.
oh, okay, so that is just your own then?
Yes.
Okay. all
Shelter
right.
itself, nobody else
So if
has.
somebody wanted to co-locate, they might have to add on or do something else or have another little outhouse or something?
Yes, and depends, some carriers can use a tiny little
Sure.
cabinets, size of this.
Right.
Some of them have their own shelters.
Okay. Other questions for Kurt? Okay, all right. Thank you very much.
If you have any questions for our actual engineers who designed this?
Do you have them here today?
Yes.
Any questions for the engineers? Okay, we'll just let that hang for now. I appreciate them being here.
Thank you.
You bet. Okay. Anybody from the public that wishes to speak in support of the applicant? Is there anybody that wishes to speak in opposition to the applicant? All right. Whoever would like to go first, feel free to, and then you can just go in order thereafter. You'll have 5 minutes each. Just give us your name and address.
Julie Bright. I live at 3108 Thompson. And the first item I brought for you today addresses something that Eric mentioned in his opening statement. It had to do with hospice. And he made the statement that's on record that hospice would not entertain this being located on their property. I have a letter that is addressed to you from HCI Care Services, who is the corporate office for the Bright Kavanaugh House. And I would like to read it. It says, "To the City of Des Moines Zoning Board of Adjustments, after the June 26, 2013 Zoning Board of Adjustment meeting, a neighbor of ours by the Bright Kavanaugh House located at 3000 Easton Boulevard brought to our attention that First Presbyterian Church of DM was seeking a variance for the property located at 3100 Easton Boulevard for the installation of a 121-foot tall tower, communication tower, to be installed by Verizon Wireless. At that meeting, the Verizon Wireless representative, Kurt Walter, made a statement that he had contacted our organization about the placement of the tower on our Easton Boulevard property. A Verizon Wireless representative has not contacted our corporate office about the project. In fact, after that meeting, which was in 2013, we contacted Kurt, and he said he wasn't interested in looking at a different location. If you have any questions about this statement, please feel free to contact me by my email, kdennis@hcivns.org. It's signed sincerely, Kelly Dennis, who's the Chief Financial Officer at HCI Care Services. So this is for you guys. The second thing I brought today is a petition. 5 people in the neighborhood have gone out and collected signatures. We have over 140 signatures of neighbors who are opposing this. So I have for you the petition from the neighbors. I also took from this petition addresses and made a map that shows you of the people. We did this in 5 days, started on Friday, so we did over the holiday weekend. There were, people not home, but the ones that are marked in pink are the residents who have signed the petition who are opposing this cell tower. So If you really listen to the people, we're saying, please don't put the cell tower here. And one other thing I'd like to challenge this whole thing is, if this church property was a residential property, where would Verizon be looking? Who would they be approaching? I mean, because they keep saying nothing else will work, except for one place that the park says, no, don't put it. So that's all I have. Do you have any questions? Yeah.
You read the letter from the hospice and said that you weren't contacted, but it didn't say if the hospice would even have an interest.
Well, that was not the issue. The issue was Kurt Walter has said he contacted hospice, and hospice said it wasn't an option. And they have never been contacted, so they can't say if they would or not, because they've never had a discussion.
Okay. But the hospice doesn't have an interest in it either, I presume.
They can't, I can't say that. They would entertain a conversation,
Okay, thank you.
because they don't know enough about to say yes or no, so, yeah. Okay, thank you.
Good afternoon, Board and Mr. Chair. My name is Brian Ruggles, and I live at 3042 Easton Boulevard. Do we have that map? Again, I feel like I'm kind of on recording here, but I own the property right adjacent to the west of the church, and then two lots also that adjoin that property. So myself, my neighbors to the east of the church, then right across the street, and of course the people right behind are the most affected by this. My wife and two kids moved again to this location. Lived in Ankeny for 10 years, loved the community, but really loved the location over here near the park. Very historic, park-like setting. We've reiterated that a number of times. In fact, I found out that directly across the street and kitty corner from the church on Easton is an address 3111 Easton, also known as Rose Hill, which according to the historical records is the oldest home in all of the Des Moines Metro, which is kind of interesting. We're kind of glad that we had this previous hearing right before ours, because you guys seem to consider that the view of the residents and those who live there was important, that the value of the neighborhood was important. So that's kind of helpful to us. I personally went out and helped with some of these petitions, and of about 50 or so that I had signed, I only had one gentleman in the entire neighborhood that I talked to that would not sign it. So there's a pretty overwhelming response from the neighborhood. This is now our fourth appearance before you on this issue. I don't know if any of you had a chance to actually go up and kind of get a feel of the neighborhood, maybe walk on Thompson or anything behind there. But it really helps to get the feel for that. Again, our neighborhood is a neighborhood that the community would try to encourage residency in, people to come and buy homes and settle down there. In talking with our neighbors, they're very thankful to be able to live in that area. One of the requirements, to my understanding, is that if there's an exception granted and a variance, according to section 134-64-4A5, that it needs to be in harmony with the essential character of the neighborhood. Again, I think we could demonstrate quite easily that it just simply is not. I cited a case last time, case number 053049, U.S. COC of Greater Iowa versus the Zoning Board of Adjustment. This was from October 11th, 2006. It's on the record there. This was according to the 8th Circuit United States Court of Appeals, and they actually upheld the decision of the Board of Adjustment to deny access for a cell tower based on two things. One, well, really three things. The size, it was much smaller than the required 10 acres. Number two, the safety factor. And number three was the impact on the value of the neighborhood based on the aesthetic appearance of the cell tower. And you can go back to the previous record. I won't take the time to quote that whole thing, although I guess I could share just a little bit of that. Okay, so you have it on the record. We also found out that just before hospice came in, that Sprint actually had tried to put a cell tower in somewhere in that hospice area. And when the neighborhoods found out about it, and Sprint realized how many people were opposed to that, my understanding is they actually just pulled that. That was back, again, prior to hospice being located there. Again, we're talking about a 70% variance on a spot that only has 3 acres. Again, with the park, you saw the map, there's an overwhelming amount of land available right there. We had heard that it was stated that the representative from Verizon had said, well, we already have $30,000 invested into this project and we don't really care to look elsewhere. I know we're a little bit at the mercy of the engineers who are here. It would almost seem that the city would be well served maybe in having their own RF engineer take a look at this to verify that what we're hearing from this one viewpoint is actually in fact correct. We maintain that there are actually alternative sites that are available. We still maintain that even though the representative from Verizon claims that he has checked every possible option, you just heard a letter from one of the sites that says that he hasn't. So we have a little question as to the actual due diligence that has been done. Ms. Westergaard last time made a statement at the end that she didn't feel like she would be willing to vote on this issue unless there was a letter from the city saying that the tower could not be placed up in that park, which we clearly don't have, just not in that one little slice of the park. In closing, let me just say this. It's very clear from the neighborhood that there's an overwhelming majority of our neighbors that are not in favor of the tower. Number two, at least from a lay perspective, that this is not the only feasible location. In fact, I don't think it's very feasible at all. We're a little bit concerned about some of the misrepresentation. And then number four, that we don't see that it's a benefit, certainly to our neighborhood, nor really to the city for that matter, when you consider the issues of property value and that kind of thing. That house that's the historical house actually is on the market at this very moment. So it's been for sale for a little while. Some curious questions, I guess, that I would pose is, in light of the overwhelming voice from the community saying we don't want this, it's interesting that city staff continues to recommend this. Certain members of this board seem to demonstrate an apparent prejudice almost in favor of the tower. And just one little note that's a side note, there have been actually survey crews already out observed making preparation for the tower to go in. So it just makes us wonder, you know, what's going on that there's been such confidence that this was going to go in. So thank you very much.
Brian, hang on a second. Any questions for Brian?
I do have one
Yes, Cindy.
question. Would you be opposed if this tower were to go onto the hospice site, if they had discussions with them? I mean, would you also be opposed to that site?
I wouldn't personally be very much in favor of the hospice site myself. It may be the better of two, lesser of two evils perhaps, but the park makes a whole lot more sense.
Okay.
Okay.
Thank you.
All right, thank you, Brian.
Thank you.
Next speaker. And again, we just encourage everybody to use your 5 minutes as best you can.
I have a signed note from Luella Vitalis, who has asked me to speak on her behalf today because she is ill.
Okay.
What's your name?
Suzette Jensen, 3127 Thompson Avenue.
Okay.
Luella Vitalis resides at 3113 Thompson Avenue. She also owns the lots adjacent to her property. So her property backs up to the site. And this is, I don't know if you can make this bigger. This is actually the view out her kitchen window. This house is a passive solar home, and most of the windows are on the back side of the house. So everything that she looks out on looks out right over the top of this church and will look right at the White Tower. Mrs. Vitalis is very concerned about the impact on her property, her view, her ability to sell the property should she need to, because this is going to be right in her backyard. Her concern is that the noise that might be created by any generator, any additional generators, if there's a co-locate, will also impact her ability to enjoy her deck and her backyard. She has a lot of flower gardens and a greenhouse, and she spends a lot of time outdoors and has a beautiful home. She's very concerned about the impact on her property value and the impact on her view. Thank you.
Suzette, just one brief question based on your camera picture there. Thank you for that. Is that a two-story or do we have a three-story with the school there? How tall is that structure?
It's a two-story home. Well, no, it's actually a one-story home. It's a walkout basement.
No,
'Cause it's on a
I'm
hillside.
sorry. I'm talking about the church and its ancillary school there. Is that a two- or three-story
two-story.
building? Okay. So she looks at an existing two-story building with 2 rows of windows. That's what she's got in her backyard now.
Right, and that white space you see, that's right over the
Right.
top, that's where that tower is.
And then the
going
tower
to
would be on the other side of the
Right on
building,
the other
but then
side. So
coming
it's
up
a
above it.
Big, open view, right there.
Gotcha. Okay.
There's right at it.
Thank you. Okay, next.
Board and Chair, Randy Lippert at 3120 Thompson Avenue, which is right there. And also I have a lot right here, adjoining right there. I'd like to start out with, I've got a letter that I want to read to you here and stuff, which is going to take every bit of 5 minutes. So, but just quickly, I heard a couple things from Kurt Walter up there and stuff that kind of bothers me a little bit because this is kind of an indication on how this whole situation has gone for over a year and stuff. He talked about a meeting and stuff and about getting input from the neighbors and stuff. I'm pretty sure if you ask the neighbors, I don't know that anybody said that they wanted to see it there. So where's he getting input from? Was I ever asked about what color to have the monopole with the cross? I don't think so, but if I was going to have it there, I would say hot dip galvanized pole instead of a white pole, okay? But my point is that, again, I think that's, Brooke had a question about that letter from the HCI, okay, the Bright Kavanaugh House. It goes to show you again that he had said that he talked to him. The reason for the letter is they hadn't talked to him. So again, it shows that he's not been extremely transparent. He tells us what he thinks you need to hear, okay, and doesn't tell you the whole story. So my point is that I just think that we need to be a little careful. I'd kind of like to see if you could see this here. It is basically a map of everything. Does that show up okay? Okay. All right. Just real quick, just because I want to read my letter here and stuff, I want you to understand the Mecca Tower is right here. I've got a big black X there. And the area that I think that he said will only work is right in the historic entrance right here in the park. And I know Ben Page had mentioned right up here also. And keep in mind when I get to talking and stuff here, you heard Kurt Walter said that they don't want to put it there because of kids playing and ice falling and so forth, okay? But keep in mind too that there's a lot of high winds in the winter that can make that stuff like projectiles. So anyway, here's the church, here's the hospice. And if I'm not mistaken, hopefully I'm not stepping out of my boundaries here, but in talking with Bob Mahaffey, Ben Page, I thought that they were talking about proposing up here, which is where the old maintenance house was that was torn down. Now you'd have to ask Ben, but I thought him and I were on the same page about that. And I want to just say real quick before I read here, I'm not an RF engineer, but common sense kind of tells you this a little bit. And you can drive around the city and look at some of the antennas. I don't believe they have to be totally omnidirection, meaning three-sided in a triangular shape. If you look, some of the cell towers can be directed. They'll have them only on one side, or maybe two. So my point is, I'm going to say that why can't you put it up here in the park if this is available, for example, and so it doesn't interfere with the towers that are over on East Hubble and Euclid Avenue. Why can't they be directed, okay, maybe bring it down lower if the height is too high, and be able to serve the same purpose, the same area, okay? So again, I'm not sure if I established my name. I think I did. Randy Lippert, and I gave you the locations. We have a horizontal ridge of hilly terrain in the Grandview area between the Guthrie Avenue and Easton Avenue. With the difficulty of this terrain, there will be future needs from many wireless communication service providers for cell sites. We need to minimize how many cell sites along this terrain by strategically planning where these sites can be. Currently, at the Mecca Cell Tower, which has been pointed out, at 3451 Easton Boulevard, that's only 1,500 feet away from the subject property that we're talking about here today, First Presbyterian Church. The Bright Kavanaugh House is right next door, which has 9.38 acres, okay, 3 times as much land, and it's less than 500 feet away from the subject property. Grandview Park and Rec Area is less than 1,500 feet away from the church. So the last 2 properties have future potential for becoming cell sites in the future, so please keep that in mind. No cell tower should be approved on the R180 subject property at the church because the lot is too small in size. It is only 3.12 acres, which has been pointed out by Brian and many others. It's 70% deficient for meeting the required amount to place a cell site. The site does not have sufficient acreage to allow for future co-locating of multiple carriers and their equipment shelters. I want to point out, in one of the neighborhood meetings that we did have with Bill Eden, the representative for the church, which I don't believe is here today, and the pastor, we were told, with a handful of us at that meeting, that they only wanted the tower with one equipment service building, okay? And on that property, because they felt they didn't have sufficient room for others. When we brought that to their attention, they were livid. They went back to Kurt Walter and said, what's going on here? We're not wanting two carriers here, okay? Because they didn't have the space. That was his words, Bill Eden. Board members, based on this fact, as substantial evidence, you should determine that the exception be denied because the site needs to be able to allow co-locating, be guaranteed. A concern of mine, which was mentioned by Kurt Walter, by the way, just a few minutes ago, about not putting it up here in the site, which is part of the park and rec where the kids play and stuff. A concern of mine is regarding ice forming on the tower and antennas. It is a fact that the ice does form on cell towers during the winter months, and this ice will on occasion not only fall onto the property, objects, and persons below, but occasionally it will be propelled through the air by high winds onto the adjacent properties, objects, and persons below. So remember, this is a residential neighborhood that will in fact from time to time have neighborhood kids that will wander innocently onto this adjacent to this land and also the adjacent properties to play. In fact, it is undisputed that Verizon Wireless Equipment Building below is to be constructed at the base of the tower to be hardened to protect it from falling ice and other objects. So to this point, the proposed cell site on the back of that 3.12 acre lot will not adequately safeguard the health, safety, and welfare of the occupants of the adjoining and surrounding property as required for an exception. Further, the danger of falling and blowing ice will diminish property values in the area of the tower. This is a zoning factor that prevents the board from granting the requested exception based on the Muni Code Section 13464, subsection 4. Exceptions shall by their design, construction, and operation adequately safeguard the health, safety, and welfare of the occupants of adjoining and surrounding property. Exceptions shall not increase public danger or fire and safety, and shall not diminish or impair established property values in the surrounding areas. Again, board members, based on these facts as substantial evidence, you should determine that the exception should be denied. Currently, the subject property does not have adequate landscape screening, especially all year round. Muni Code Section 134-347, subsection 10 states that the adverse visual impact of a tower shall be minimized through careful design, siting, landscape screening, and innovative camouflage techniques. Having an unobstructed view of a tower from one's home every day would diminish most property owners' enjoyment of that property. Common sense dictates that having such a tower in the sight line from and so close to one's home reduces the value of that home, especially when the property owner is not the one receiving the income from the lease. Ask yourself in making the determination today, taking into consideration protecting the essential character of the surrounding area, how would the appellant be able to meet the code requirement and criteria when the practical difficulty of the subject property's elevation is lower than most of the adjoining and surrounding residential properties, especially those to the north? Board members, based on these facts and substantial evidence, you should determine that the exception should be denied. In this area, there is a much better location, which has been pointed out by Ben Page and others. That would be the Grandview Park area, which is less than 1,500 feet away from the church, and in particular, at East 32nd Street in Guthrie. The elevation of this land is much higher than the subject property. It is one of the highest points in the general area. And this is just pointing out from an aesthetic point of view more than anything else. Again, if they need to lower the antenna, if they need to direct the antennas, whatever they need to do, do it. Make it work. It also has sufficient acreage to allow for multiple wireless service providers to place their antennas on one monopole cell tower, and also would allow them to place multiple equipment service buildings below. So that way we could take care of this area for a future of maybe 15, 20 years, who knows, or longer. This location with adequate planning will protect the essential character of the surrounding residential properties for now and into the future. If we don't make good decisions now, then we will be guaranteed a horizon of cell towers in the area with one or two carriers on each one. This area is part of the City of Des Moines Park and Rec, as Ben Page mentioned, the director, and they have offered a portion of this real estate as an alternative site at a substantially reduced price, but Kurt Walter, the representative for Verizon, has indicated that he's not interested. In closing here, Kurt Walter, the representing Verizon Wireless, has only been pursuing the church and not adequately investigating all other feasible alternative sites, including Grandview Park and the Bright Kavanaugh House, in full. So board members, again, based on this, as a fact, as substantial evidence, you should determine that the exception should be denied. And one last thing, the telecommunications...
One last thing, Randy.
You got it.
One last thing.
Telecommunications Act of 1996 has a considerable amount of standards, but what is most relevant to this issue is that Congress intended, in spite of the high degree of federal regulation in the area of wireless communication, to allow local zoning boards to continue to do what local zoning boards traditionally do best: make reasoned decisions regarding the appropriate use of privately owned property for the public. Good, thank you. Any questions?
Any questions for Randy? All right, thank you very much. Okay, I do want to remind everyone, I try to be as generous as I can. As I stated at the beginning of the hearing, everybody has 5 minutes to comment. I don't like to be rude to anybody, but I do have the military time watch. And I know that some of our speakers can be concise and effective in their comments. So timing watch is on. Who's next?
Suzette Jensen, 3127 Thompson Avenue. We're all here because we're concerned about the value of our property and the impact that this might make on the value of our property. But we're also concerned about the church property, about a church in our neighborhood that didn't bother to contact any of us that they were considering this tower. The only contact we had with the church was after it came before this board. The church is choosing to do this because they need money, as many churches do. But this church also has a very low attendance and a very low membership. So as neighbors in an R180 neighborhood, we're very concerned about that property. What happens if that church fails? Today I was reading the contract with Verizon, and in the contract, there is a first right of refusal, that Verizon shall have the right to buy that property should the church fail. Is it your intent that a business should buy this property in an R180 neighborhood? I also had a conversation with Ben Page about, looking at the park. And he told me that basically they weren't interested in looking at the park, that they had $30,000 invested in this site and they weren't interested in spending any more money looking at someplace else. I find it very, very, very hard to believe that this is the only spot. We were told that they sent a letter to the Baptist Church on East 33rd. We've had some confirmation of that, but we weren't able to get it documented. And that would be further away from the park property that he was looking at. We're told that he's concerned about children and all that. Well, why is a church allowing a site to be located right by their front entrance, their handicapped entrance of their church? So we're very concerned that we're not being told the whole truth, that Verizon's agents have not explored the other options that are available to them. I know there's a ridge there, and I know that I sit on the downhill side, the church sits further downhill than I do, and all of us do, and it's uphill from there, but that ridge goes around the park. There's a lot of property. It might take a different design of tower, but the map he showed that a lot of the area they're trying to reach is right down by the Kmart area, right down where the city says they could locate one. It might cost them more money because it might have to be a taller tower. So I would ask you to refuse them, make them look at something else, make them truly investigate something else, because they're not going to until this board turns them down. Thank you.
Thank you, Suzette. Any questions? Okay. Next speaker.
Good afternoon. Marty Mock, 2701 Arthur, speaking on behalf of Northeast Neighbors. I watched the last meeting on YouTube this morning, the whole thing. Glutton for punishment.
Yes.
My comments and reasons for standing against this location has not changed, and that's already part of the record, so I won't repeat any of that.
Okay, appreciate it.
I do want to make some comments regarding the applicant's statements after the public portion of the meeting last time. And since we could not respond to any of those particular comments. One common thread that I see researching this issue in regard to both the Telecommunications Act and court cases in relationship to this is that wireless carriers are required to prove that there are no other viable locations that will work. They're the ones that have the burden of proof, not the citizens that are coming up and speaking against it. Saying that, as has been mentioned before, there's a claim that they've already invested over $30,000 on this particular site. That's fine, that's a business decision, but it does not go towards burden of proof. Burden of proof comes from a zoning position. In the last meeting, the applicant said, "We have never said that this property is the only location," and that's a quote. Later, from Buell Consulting letter that you have as your on your record here, it says, "We have met with the Park and Rec staff and concluded that the city staff is not in favor of placing a facility in the only location in Grandview Park that will provide the needed coverage for Verizon along Easton Boulevard." Arising out of that last meeting, the possible location of Easton and East 33rd, 2 blocks from the existing site and in the park, was discussed. The applicant has stated that they had checked every part of the park to see if it would work, and he said yes. When he was asked by, I think, Mr. Gear, did you check the site at East 33rd and Easton? He said, well, no, we haven't checked that site. One of the things he agreed, I quote, "I will make sure that gets done." Yet we see no report in his testimony today that that was done, nor do we see a report in regard to the footprint on how that site would work. I did go back and check again. I mentioned in error last time that that site might be lower. It is actually higher than the existing site that they're looking for right here. And again, it's just basically 2 blocks away right along Easton Boulevard. Ben Page has submitted a letter and has answered the questions there. Maybe the real question is, and maybe we should ask Mr. Page, is did the site at East 33rd and Easton actually get discussed during that meeting? And what was the actual words being said? In conclusion, the Telecommunications Act does give cities the ability to regulate the location of cell towers within the limitations of the federal law. In the staff recommendation, we find the following standards for granting an exception, and it's found on page 35 of your staff recommendations. The board shall ensure that exceptions by the design cannot do a number of things, or have to do a number of things, and down towards about 2/3 thing, and shall not diminish or impair established property values in surrounding areas. And then the list 4 different tests that have to be met. 4 that have to be met, not 1 that has to be met or 2, but all 4 should be met. The 1 is kind of the starting of the exceptions. The number 2, the exception is reasonably necessary due to practical difficulties related to the land in question. Such practical difficulties cannot be overcome by any feasible alternative means other than an exception, and the exception is in harmony with the essential character of the neighborhood of the land in question. The Telecommunications Act has nothing to say regarding this. We can still follow those exception rules, and they are rules as part of what this board should do. And so in conclusion, I believe that he has not met, they have not met the test of an exception during this way, that they have been less than candid about the different people they've talked to and the conversations that they have had, and they have not done due diligence in looking at the one property this board asked them to look at the last meeting. And I ask you to deny the exception.
Right on time, Marty.
Thank you.
Any questions for Mr. Mock?
Thank you.
Okay, thank you very much.
Looks like I'll get to be the last person. Sorry, my name is Dale Marks. I live at 2103 East 29th Street, so I'm outside of the 300-foot thing. That's why one of the reasons I'm down here, one of my neighbors came over, the ones that's going to live right next to that, and asked me to sign the petition last night. And I did recall, and I don't know if any of you were in the meeting when Sprint tried to apply for this on what's currently the hospice territory right now. That was 18 years ago. And I got notified that very day that there was a meeting that day, because that was the day I was moving into my house at 2103 East 29th. That would be my house right here, completely obliterated by the trees that are covering it from that aspect there. So like I say, I live a little bit outside of that area. I probably won't be able to see this. I haven't been able to had the time to look at all that yet. But Ms. Smith, you talked about would one of the guys have opposition to the hospice territory for that, and I definitely would have, because where they were going to be putting it, it would have been the view out of my back window. So to me, that is not an option. I don't know about the Mecca site, but I do kind of know a little bit about the Grandview Park site and a couple of the spots that they talked about putting it there. And I can understand Mr. Page's opposition to putting it at the entrance to the park. It is actually a beautiful entrance. I could maybe understand neighbors having an aversion to being right there where the old maintenance house was. I know Mr. Dar that lived there for many, many years until that house was tore down. But there are some beautiful homes across the street that might have an aversion to that. The spot that you looked at